Hi, my name is Rob Collier. I'm with California Drivers Advocates, and today I'd like to talk to you about what causes the loss of an administrative per se hearing, and if a hearing is lost, what the penalties are. Anytime a person is arrested for DUI in the state of California, they are subject to the laws called administrative per se laws. That's the category of hearing that we're talking about today. If you have been arrested for DUI and you want to prevent the suspension of your license, there's a requirement that you be in contact with the DMV within 10 days to request a hearing. If you don't do that, that will cause an automatic loss of your driving privilege, and so 30 days after your arrest, your license would become suspended. The other way that an APS hearing is lost is if you conduct the hearing, but the hearing officer rejects your defense and the hearing officer sustains the suspension. In almost every case, whether you've not contacted the DMV within 10 days or you've lost a hearing, in almost every case, a person is eligible for what's called an IID restriction. So in years past, you would actually have been off the road. You would have suffered the loss of your driving privilege for a minimum of 30 days. But under today's law, however, if you have not requested a hearing in a timely manner, or if you've lost your hearing, then you're entitled to have a restricted license as long as you've installed an ignition interlock device in your car. An IID device is essentially a breath device that you blow into before your car will start. As long as you've installed an IID device, and as long as you keep that device in your car, the restriction is just that. You can drive anywhere, anytime, without any further restriction. You just have to have the IID device in your car for a specified period of time. Of course, a loss at the DMV means that you also have got to pay a reissuance fee, you've got to file an SR-22 form, and you have to be enrolled in a drunk driving school. The only thing that trumps that, the only thing that will actually bring you off the road following the loss of a DMV hearing for a DUI is if you are accused of a chemical test refusal. If a chemical test refusal is alleged and you either do not request a hearing in a timely manner, or if you lose your hearing, then your license will be revoked for a period of 1, 2, or 3 years, depending upon the facts in your case, and there is no option for an IID restriction. So if you've been arrested for DUI and you just don't know where to turn, give us a call. You can go to our website, you can call us for free information. We're here to help.